This is a brief discussion of the whys and the hows, plus the process of putting your house or other assets into a living trust. How? Number 1. Create a trust document. The trust document is a legal document that outlines the terms of your trust, such as who the beneficiaries are, what property is included in the trust, and how the property should be managed. You can create a trust document yourself or hire an attorney to help you. But generally, people consult a licensed attorney because trusts can become complex legal documents. Number 2, transfer ownership of your house or other assets to the trust. Once you have created a trust document, you need to transfer ownership to the trust. This is called funding the trust. This can be done by signing a deed and having it recorded with the county recorder's office. Generally, with a living trust, you manage the assets in the trust. But you will also want to designate a trustee. This will be a person or entity that will manage your property and distribute it to your beneficiaries after you die, or if you become incapacitated or unable to perform the duties of trust management. You can choose a family member, friend, or professional trustee. When should you establish a living trust? Timing of establishing a living trust. You can establish a living trust at any time, before, after, or simultaneously with the purchase of your home. For more information on transferring title of a house or any other asset into a trust, please ask for our information on funding a trust. How long does it take to create a trust? The amount of time it takes to create a trust depends on a number of factors, primarily the complexity of your trust and what other ancillary documents, such as powers of attorney and medical directives, you elect to have done along with your trust. Generally, an attorney will require several weeks to a few months to complete the process of producing an estate package tailored to your needs. Why are assets moved into a living trust instead of a normal will? There are a number of reasons why people put their homes or other assets in living trusts. Some of the most common reasons are these. Number 1, to avoid probate. Probate is the court-supervised process of distributing a deceased person's assets. It can be a lengthy and expensive process. By putting your home in a living trust, you can avoid probate and ensure that your home or other asset is transferred to your beneficiaries quickly and easily after you die. Number 2, to provide for a minor child. If you have a minor child, you can use a living trust to provide for their needs after you die. You can name a trustee to manage the trust and distribute the assets to your child when they reach a certain age. Number 3, to manage your assets if you become incapacitated. If you become incapacitated due to illness or injury, a living trust can be used to manage your assets and provide for your needs. You can name a trustee to step in and manage the trust until you are able to do so yourself. Overall, putting your home and other assets into a living trust can be a good way to protect your assets and ensure that your wishes are carried out after you die. However, it is important to understand the pros and cons of living trusts before making a decision on this subject. As your individual situation may be different or more complicated, it is generally wise to consult with an attorney to make sure that a living trust is right for you and your situation. If you are ready to schedule a consultation with a licensed attorney with decades of legal and financial practice experience, get in touch with us. You can reach us at theburdettelaw.com or call us or send us a text anytime, day or night. Thank you for listening. This is Leisa at Burdette Law, wishing you a good day. Remember, call us at 901-756-7878, the Burdette Law Firm of Western Tennessee.